Mr. Shanmugam.
Thank you, Madam. I think I wanted to say I thank members for the overwhelming support for this bill to repeal the Sedition Act. The fact that only Mr. Pereira wants to speak, I think, does suggest overwhelming support, and he supports it as well, so I thank him for that. I will address the clarifications that Mr. Pereira has raised. I think the first question that he asked is on the time limit for prosecution. Under the Sedition Act, actions have to be brought within 6 months, and there is no time limit under the amended provisions. To understand this, I think we need to look at the Sedition Act a little carefully. It's we are talking about very different offenses. Let me make that clear. The 6 months time limit is in Section 5 of the Sedition Act. Section 5 then must relate back to Section 4. For example, 4(1)(a). Any person who does or attempts to do or makes preparation to do anything which would have a seditious tendency. So what's important is seditious tendency. That in turn brings you back to Section 3(1), which defines what seditious tendency is. A seditious tendency is a tendency to bring into hatred or contempt or excite disaffection against the government. If you look at D, to raise discontent or disaffection amongst the citizens of Singapore or the residents of Singapore. E, to promote feelings of ill will and hostility between different races or classes of the population of Singapore. So, if you went out there and you said something that makes people upset with the government of Singapore, under Section 3(1)(a), that's an offense. If you raise the discontent or disaffection amongst the citizens, doesn't matter whether it's against the government or not, that's also an offense. So it's a very extreme legislation, and we are doing away with it. And you can understand why a time limit of 6 months has been put. As I said earlier, I think on the strict wordings of Section 3, Mr. Pereira would have committed offenses several times, and I'm likely to have committed offenses several times as well, both in my previous incarnation and now, because it talks about raising discontent, disaffection amongst the citizens of Singapore, and exciting disaffection against the government. And these all really, they haven't been relevant for a very long time. Now, this, over a period of time, different provisions have come up, as I explained in my opening speech, second reading speech. For example, the Administration of Justice Act, on contempt of court, on interfering with proceedings in court, on bringing the disrepute to the judiciary. So there is legislation that deals with that. Section 267C takes some parts of Section 4. That's really on violence, getting people to violently do something and contrary to the law. So there is no sui generis taking off the Sedition Act and putting it in. What you now have in the other pieces of legislation are completely different animals. The essence or the heart of the Sedition Act is actually being done away with. So the rationale for the 6 months has got to be seen in the context of what the Sedition Act provides. In the other legislation, there's the normal criminal cases. You take the normal criminal approach, which is that there is no time limit on prosecuting offenses. Yeah. So, for example, if you look at Section 267C, which is the amendment that's coming along, 267C of the Penal Code is an existing provision with no time limits, and it originally is dealt with usage, making, printing, reproducing, distributing, communicating, any incitement to violence. So you can see it's a very different type of offense, counseling disobedience to the law or to lawful order of a public servant, which is or likely to lead to a breach of the peace. So it's that sort of offense. It's got nothing to do with exciting disaffection against the government or making people unhappy. It's a very direct, focused offense, and we are making some changes there, including to the mental elements. So, specifically, we are covering statements made, words uttered, and reproduction, sale, offer for sale, and importation of documents. So that's the reason why the 6 months requirement under the Sedition Act is not being ported over, because basically most of the key elements of the Sedition Act, which kept the colonial rule in place, are being done away with. Bits and pieces which are relevant for modern Singapore have already been moved out into other legislation. Now, one last bit is being moved out. Now, the second point that Mr. Pereira makes, and let me see, on the counseling of civil disobedience and the mental element. Again, if you look at Section 267C, conveying information about civil disobedience is in and of itself not an offense under 267C, because if you look at 267C, it's got 1A, B, C, D. Then it says in the proposed amendments, the person does any of these things intending for violence, disobedience to the law or such lawful order, or breach of the peace to occur. So the person must have intended for the violence or the disobedience or the breach of the peace to occur, or knowing or having reason to believe that such consequences will occur. And likewise, under these 267 subsection 2, D, there is also a requirement for knowing or having reason to believe and intention. So the mental elements are set out in the proposed amendments, which are at a higher level than what the Sedition Act requires. Let me see. The third point Mr. Pereira makes is, why is it being made arrestable? Again, I think you need to compare Section 298, 298A, which are already in our statute books, with Section 3.1. I just took the House through Section 3.1, and as I mentioned, a large number of us would probably have run afoul of Section 3.1 at one point of time. The reason for low thresholds in Section 3.1 is due to its own history of maintaining colonial rule. And you've got to look at Section 3.1, and you've got to see what's important is that 3.1A is a seditious tendency, is a tendency to bring into hatred or contempt or excite disaffection against the government. And then, of course, you've got B, C, D, E, some of which have been moved over in the past, and one aspect is being moved over now. And then Section 3.2 says, well, it shall not be deemed to be seditious by reason only that you are trying to show that the government has been misled or mistaken, or you're pointing out errors or defects in the government as by law established, or you are trying to persuade citizens of Singapore or the residents in Singapore to attempt to procure by lawful means the alteration of any matter in Singapore, or to point out with a view to their removal any matters producing or having a tendency to produce feelings of ill will and enmity between different races or classes. So you see, this has got really nothing to do with the offenses that are now found in other legislation, including the slight amendments to Section 267C, which is on counseling disobedience to the law or the view to breaking of the law. The Sedition Act, Section 3, subsection 2D, has some reference to producing feelings of ill will and enmity between different races or classes, but you must look at it in the light also of Section 3, subsection 3, which says that the intention of the person charged at the time he did some of these things, seditious words, are irrelevant. So it's, your intention is irrelevant. If you did what you did and it has these tendencies, then you are liable under the law. Your intention, your knowledge is completely irrelevant. So it's a very different animal, very different kind of offense, and one could almost say very sui generis. We are not going down that route. If you look at Section 298 and 298A, which, by the way, is not an issue today, it's if you, by words, spoken or written, or by signs or visible representation, promote or attempts to promote on the grounds of religion or race, ill will, and commits any act which he knows is prejudicial to the maintenance of harmony between different religious groups. That's 298A. So the element of intention is incorporated in 298A-B. 298 refers to deliberate intention. It's relevant today insofar as offenses are being made arrestable. So one can ask, does it have to be made arrestable? What's the prejudice? I mean, those are fair questions. And the answer is, I don't think the question can be asked by reference to the Sedition Act, which, as I said, deals with quite different subjects, and the exceptions don't make sense in the context of these provisions. But I think it's legitimate to ask, do you need to make it arrestable? I think, and the counter question is, what is the prejudice if it is made arrestable? It allows the police to move faster, it allows the police to intervene, and these are serious matters. And that's a matter of judgment. I think Mr. Pereira's fourth and final point is whether the MRHA amendments are already in force. No, they are not yet in force. I think we answered a PQ in September. The amendments were passed in 2019, but normally with many such legislation, which affects a large group of people on the ground, here it's all the religious organizations. They have to make disclosures, they have compliance requirements. You can't just bring the act into force without making sure, and religious organizations are differently resourced. Some are well-resourced, some are less well-resourced, some are essentially a very small operation. So you need to give time to all of them to resource themselves, of being able to comply with the requirements of the legislation. In fact, you've got to take time to educate them, talk to them about the requirements. We also have to make sure that our own systems are set up which are able to receive the information that comes through. And another subject which I've spoken about quite frequently in this house is that we are short of officers, and we now have to find officers who can be trained to deal with these specific returns that the religious groups will be giving. So there are a number of different factors here. We will do this as quickly as we can. As I've said, the training of the investigation officers on the thresholds for the amended offenses is ongoing, and that will take a little bit of time. But also the ground, as in the religious organizations, also need a little bit of time, and our systems need a little bit of time. So we will bring it into force as soon as all these things are in sync. Madam, once again, I thank members for their support of the bill. Thank you.
The question is that the bill be now read a second time. As many as of the opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it.
The Sedition Repeal Bill.
Committee stage, what day?
Madam Deputy Speaker, I beg to move that Parliament will now immediately resolve itself into a committee on the bill.
The question is that Parliament will immediately resolve itself into a committee on the bill. As many as of the opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it. The question is that clauses 1 to 8 stand part of the bill. As many as of the opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it. Bill to be reported. Minister for Home Affairs.
Madam Deputy Speaker, I beg to report that the bill has been considered in committee and agreed to without amendment.
Third reading, what day?
Madam, now I beg to move that the bill be now read a third time.
The question is that the bill be now read a third time. As many as are of the opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it.
The Sedition Repeal Bill.